ask it immediately. But that is not going to be possible on this occasion because there are just too many participants. So what I would ask all of you to do is to reserve all of your questions for the end, and we will have a brief question and answer session towards the end. Now with that, if I can ask Varad to start with our presentation. It takes a minute, here we are, okay. So Varad, next slide. The outline of our presentation today is on the screen in front of you. It's fairly simple, and it follows the topic that that was given to you before we started. Varad will first make a few introductory remarks and provide a little bit of background and the essential elements of force majeure. I will then take over and talk about a few concrete issues that arise concerning the application of force majeure and the practical application of the doctrine. We'll then talk about the doctrine of frustration in the context of force majeure, and we'll also speak about the doctrine of hardship. Now, there are important differences with force majeure and hardship. We'll talk about those as well. And then we'll make some concrete recommendations in terms of what parties should be doing or should think of doing if they are faced with a situation in which they would like to either claim force majeure or rely on the doctrine of hardship or similar defenses. And then we'll make a few concluding remarks. Now, as I said, we'll take questions towards the end. So Varad and I hope to speak collectively for around 40 to 45 minutes, leaving aside 15 to 20 minutes at the end for questions. So that's all that I had in terms of housekeeping and general outline. Varad, if you have nothing else to add on that, I leave it to you to start with the introduction. Thank you.
Thanks very much, Rahul sir. A very good evening to all of you. I hope all of you are staying healthy and doing well in these unprecedented times. To begin with, I thank the organizers for this wonderful initiative. And even more so, I thank Rahul sir for giving me this platform to interact with all of you today. Now, as students of law, we have always been taught to ask questions, to ask why, what, when, and how to everything that is put forth to us. So let's ponder over why do we actually need the doctrines of force majeure and hardship? Because after all, contract is a creature of human interaction. So what does an act of God or nature, or for that matter, any supernatural forces have to do with this? When two parties enter into a contract, they believe that each party will perform its reciprocal promises. This belief stems from a simple principle, that is pacta sunt servanda, meaning agreements must be kept. But what if an event prevents the party from keeping the agreement? How do we then decide the liabilities and reliefs of the contractual parties? If we rigidly apply pacta sunt servanda, it runs counter to the very principles of reasonableness, justice, and good faith, especially when uncontemplated and extenuating circumstances either prevent the performance of the contract or render the performance of a contract problematic. So the purpose of force majeure and hardship is therefore A, to accommodate and adapt to these extenuating circumstances, and B, therefore, to in turn serve as a precaution against the risks posed by certain economic, political, and natural disaster events. Now, as the pandemic set in, we all have witnessed a litany of lockdowns and restrictions across the globe. Several businesses faced operational hurdles. There was a shortage of labor, which led to closures of ports and workplaces. In sum and substance, all these have in turn affected the global demand and supply curve. The IMF has already projected India's GDP to venture in negative integers as we continue to battle an ever-increasing rate of the coronavirus disease. But what is relevant to us today is whether this plunging economy increases the rate of cases where force majeure and hardship is invoked. To understand this, we now turn to a survey which was recently concluded by the law firm Norton Rose Fulbright. Now, in this graph, you will see that the energy sector globally sweeps a large part of the economy in all continents of the world. In this graph, you will see that as opposed to the pre-pandemic era, as the survey suggested, players in every sector today are more inclined to take recourse to force majeure and hardship for contractual reliefs. You will see a similar trend when we analyze the parties' inclinations according to their locations. And if you notice the previous graph carefully, the energy sector is likely to see a humongous spike in force majeure and hardship cases. Now, again, I ask a question. Why do we see this humongous spike in the energy sector? For that, we need to look at the structure of oil and gas contracts. Oil and gas contracts are a unique set of contractual arrangements. Most of them are between private entities and state parties, and therefore political as well as legal risks are aggravated. Usually, these contracts span 20 to 30 years and attract investments that are extremely high as compared to any ordinary commercial transactions. The geological, technical, environmental, and other risks also compound over time. And one of the main features, in fact, of the oil market during the 1990s was the relative stability of oil prices. However, as you see in this graph, these prices fell to levels not seen in more than a decade in the period of 2014 to 2016. And just as we thought that these wounds were healing, the COVID-19 pandemic accentuated troubles further. Given the vulnerability of this sector to the pandemic, all industry players today are looking for strategies to cope with these rampant, unprecedented changes. India contributes to 5.2% of the global demand. It is among the top 3 large markets in demand growth and the 4th in the world in refining capacity. We are heavily imports dependent, with oil imports at 84% and gas imports at 53% of the respective annual demands. If you look at fiscal year 2019, the import bill constituted 25% of the budget. And therefore, it is but natural, as you see in this slide, that India is at the epicenter of force majeure activity in the oil and gas industry. Now, I've spoken a fair bit on the introduction part, and I've uttered force majeure and hardship a lot many times, but what is force majeure? And when I ask you this question, many of you would reply in a heartbeat, and it is an unpredictable and unavoidable event which is beyond the control of the party. As simple as this seems, the reality is complex. You will realize why I say this as I discuss the essential characteristics you see on the slide one by one. Now, first comes exteriority. The event which renders performance impossible must be independent. That is, at a minimum, the event must not arise from the fault of the debtor. So, for example, the captain who was on the coast of Somalia cannot invoke force majeure if he himself becomes a victim of piracy. Things become even more complicated when the non-performing party is not at fault, but the disruptive event is not external to him. For example, if there's a restaurant owner who serves his customers fish that is infected with undetectable toxin, could the restaurant owner then argue that the event was beyond his control because the event only occurred in the fish? What is even more convoluted and what is even more relevant for us today is, what about the sickness of the non-performing party? Can we say that sickness is external to a non-performing party? I may say no, the disease occurs in the non-performing party's body, but you may argue that the disease comes from an external cause. Except for creating unbearable discrimination between patients, one cannot distinguish between those who suffer from endogenous and exogenous causes of illness. To sum up, therefore, exteriority is assessed not only in relation to the non-performing party, but also in relation to its sphere of responsibility. Now, the second is unpredictability. And to my personal belief, there is nothing more controversial than unpredictability. Because it is paradoxical that almost everyone requires that the event be unpredictable, but no one can actually define what unpredictable truly means. For instance, if I ask you to enlist events that are unpredictable right now, you may cite a tsunami, you may cite a terrorist attack, or even a cyclone. But after you reach a dead end and cannot think of any such events further, I may submit to you that you have thought of these events. If you have thought about them, it means that they are in fact predictable. In the same vein, if one thinks of risks, it means that he or she is able to foresee them and therefore they are no longer predictable. Strictly speaking, therefore, nothing is predictable unless the event has never happened in the past. But for reasons of humanity, let's try to twist this meaning a little. Let's say that unpredictable does not mean cannot be foreseen, but what it means is that there was no particular reason to foresee. But even this approach towards unpredictability is problematic because a wind blowing at 130 kilometers per hour will be predictable in one place. But as I move 5 kilometers away from the same place, it may be unpredictable there. Therefore, for me, predictability is an elusive criterion. Third is irresistibility, which according to me is the most pivotal criterion. It means two things. On the one hand, it is impossible to avoid the occurrence of the event. This can be called as unavoidability. On the other hand, once the event occurs, the performance of the duty is totally out of question. This may be called as unsurmountability. So in short, the event must have neither been avoided nor overcome. To conclude, therefore, force majeure is a concept that transcends with situations and scenarios, and there can be no straitjacket characterization of force majeure. Now, if you look at the force majeure clauses in contracts, they vary in the tenor and details widely. Some clauses may be extremely simple. Parties may even put them in the standard terms or conditions, or may even put them into some corner of the miscellaneous section of the contract. But in such cases, where wording as well as structure of force majeure is not detailed and accurate, its meaning is left to be determined by the courts or arbitrators. To avoid this, it is helpful if the clause sets forth some specific examples of acts that will excuse performance. For example, the force majeure clause on your slide right now is from the contract in the JSPC versus Yemen case, which is an ICC arbitration case where the award was delivered in July 2015. We had attached it as a part of the reading material. And you will see in the second paragraph, riots, insurrections, wars, strikes, etc. as examples of force majeure. But despite their fullness of detail, they are not intended to be exhaustive. A list, even if given, it only supplements the abstract definition. Now, some clauses may even go a step further. For example, consider a very recent case, and the clause which you see right now on the slide is from a force majeure case decided by the Delhi High Court on May 29, 2020, Halliburton versus Vedanta. This is again attached in the reading material. It refers not only to examples, as you will see here, but also to a standard in order to determine whether the effect of the event was avoidable or not. For instance, in this oil and gas contract, you read the very first paragraph on the slide. It requires the parties to exercise diligence and reasonable care. Now, on this backdrop, I now invite Rahul sir to explain to us how these clauses will be interpreted when they come into life.
Thank you, Varad. Sorry, it took time to unmute my microphone. Thank you very much for that introduction and for setting out the elements of force majeure. I'm going to take over now and quickly share my screen. Just give me a minute and find my way to the slide that you left off at. Okay, here we are. So this is what Varad has spoken about is he set the context out for force majeure, hardship, and frustration in the oil and gas industry, and why we think that it's important to talk about these particular doctrines at this time. There is, of course, the effect that the world is facing on because of coronavirus, and all major economies in the world are going to face quite a serious backlash because of the effective suspension of business during this period. But where the oil and gas industry is doubly affected is also, as Varad mentioned earlier, the oil price volatility. And that's the combination of the two is likely to lead to a spike in the number of claims to force majeure, frustration, and hardship. And again, Varad ran through the slides where a law firm has conducted a survey and analyzed and understood that the energy sector in particular, globally in fact, is going to see a large number of these claims. So the issue is quite important and is somehow exacerbated in the context of the oil and gas industry. Varad also very efficiently set out the essential characteristics of force majeure. And the essential elements that you need to think about when you're faced with a force majeure provision. Now, on the screen in front of you, you have the contract in GSPC versus Yemen. This is an ICC arbitration in which I was involved, where you had an oil and gas company, an Indian oil and gas company that had sought force majeure against the Republic of Yemen. The oil and gas company was contracted to engage in exploration and subsequently potentially production in 3 fields in Yemen. And in 2014, there was a considerable, or around 2011 to 2014, there was a considerable deterioration in the law and order situation in Yemen. And the Indian company therefore alleged that it was unable to perform its obligations under the contract on account of force majeure. It was opposed very strongly by the government of Yemen, as you can expect, which contended that the force majeure events that the Indian company had alleged or was alleging to exist were firstly not force majeure events, were events that had taken place in areas that were not related to the oil fields, where the Indian company was supposed to conduct its activities, and that the Indian company was unnecessarily suspended performing its obligations under the contract because it felt that, because at least the government alleged that the Indian company was no longer interested in performance. The price of the contract had become too expensive for it. Now, in the middle of all of this and the main substance concerning force majeure, there was also the question of the enforcement of bank guarantees and several other commercial issues. And I would encourage you to read this decision, those of you that have an interest in these areas, because I do think it's a good example of the various kind of issues that can arise when you're considering an oil and gas contract and the application of force majeure. This is the first case study that we've provided to you in the reading material before this seminar. The other case study that we had given you, I think, is the Halliburton versus Vedanta decision. This is a single judge decision of the Delhi High Court. Again, there's an excuse of force majeure that is sought to be relied on. And the court, because of the measures that were taken or that had to be taken as a result of the coronavirus pandemic, the court does a very detailed analysis of the force majeure provision, very detailed analysis of the actual obligations of the party, and comes to a considered decision And I would encourage you to read that decision as well, because it's quite illustrative of the kind of issues that arise or commonly arise when you have a force majeure provision being invoked by one of the parties. Now, in terms of interpretation, I think it's clear that you need to interpret the provisions of the contract in the words that they appear. And here on the screen in front of you, you have the force majeure definition in GSPC versus Yemen. And here, what is said, and you can read it for yourselves. There is a fairly lengthy definition of what force majeure means, and there's words used like insurrection, riot, war, strike, and then there's a general catch-all, which is that the force majeure event should not be due to the fault or negligence of the party claiming it, whether or not that event is similar to the foregoing, and it must be beyond the reasonable control of the party. Now, I think it sounds very reasonable and easy to interpret, but it leads to a large number of complications, and I'm just going to talk about a few of them so you have an idea of what it involves once force majeure is invoked. The first issue that the government, the tribunal had to face was how exactly to interpret the clause and what events should be considered. Remember that the background of this case was that the security situation in Yemen had deteriorated, that there were armed militia roaming certain parts of Yemen. And the question was how exactly to fit those events or the facts on the ground into the context of force majeure. And here the tribunal took the supposedly easy way out and said that we've noticed that there is a catch-all provision that says that you don't really need to classify the acts in question into any one of the categories that have been identified. So you don't need to necessarily identify something as a riot or an insurrection in order for the party to claim force majeure. It is sufficient if the characteristics that are mentioned in the clause are satisfied. So the tribunal listed out the characteristics and said and found eventually on the facts that the security situation in Yemen was such that it did constitute a force majeure event. Now, another issue that arose is the government of Yemen argued that it's all well and good to have a force majeure clause in the contract, but that clause is not exhaustive. What you should do, or what they asked the tribunal to do, was also to add into the conditions of force majeure the Yemeni law requirements of force majeure. So Yemeni law contains certain additional tests to be satisfied before force majeure can be claimed, and the government of Yemen asked the tribunal to rely on those tests. And the tribunal gave short shrift to this argument. And observing very clearly that the contract says that for the purposes of this agreement, for the events constituting force majeure shall be. And there was therefore no provision, so said the tribunal, to incorporate additional elements elsewhere that were present, for instance, in Yemeni law. So the tribunal stayed true to the parties' agreement in their contract and applied those characteristics, those criteria that the parties had agreed on and specified in the contract. So that's the first test, so to speak, that you have. Do you have to, in addition to the force majeure provisions in the contract before you, can you also impute additional characteristics or additional requirements from, for instance, the applicable law? Another interesting issue that arose in this case is what exactly is meant by the word riot. Now, the word is used in the clause, but how do you define it? How do you give effect to it? On the government of Yemen side, it was argued that in order for there to be a riot, in order for a violent act by a group of people to constitute a riot, you need to have a declaration from the police. And since there was no declaration from the police in this instance, there could not have been a riot. And the tribunal again rejected this analysis, saying that when the parties entered into the contract, what they had in mind was a common understanding of the words right. They did not intend really to include the word right in the contract on the basis of the definition or the understanding of the word right under Yemeni law. And therefore, here again, we are going to stay true to the contract and give effects to the word right as is commonly understood. So you see, you have a very simple force majeure provision that on first reading at least very sets out quite clearly the requirements of what constitutes a force majeure event. But when you get into the specificities, you notice that there are multiple problems that can arise. Firstly, is the clause exhaustive or not? Can it include should other requirements be included in? Secondly, in order to give effect to the particular meaning or to particular words used in the clause, where do you turn to? Do you turn to the dictionary? Do you turn to the applicable law? Just a very brief idea of the kind of issues that you have to enter into when you're thinking about force majeure. Now, when we're talking about force majeure, there are, of course, multiple heads that we can talk about. But what is important is also to understand for these purposes of today, when we're talking about force majeure in the oil and gas industry, particularly in the world that we are in right now, the effect that force majeure has is twofold. Either once you've issued a force majeure notice, the most common effect is that the contract is suspended. The performance of obligations under the contract, to be more specific, or certain obligations under the contract is suspended. And the other is usually termination. Again, talking on the basis of examples, you will see this is again the force majeure provision in the Yemen case. And you will see the effect that the force majeure has in the first provision itself, that is Article 22.1. It says there that non-performance certain kinds of non-performance will be excused to the extent that performance is not possible because of the existence of the force majeure event. Other kinds of performance, however, is not to be excused in any event at all. So you have to be careful when you're thinking about force majeure. You have to be careful of what exactly it is that you are trying to excuse and what exactly is suspended. In the Yemen case, what the invoking party, that's what GSPC sought, was a suspension on carrying out any exploration activities. They alleged that they were simply unable to do it. And it was a very interesting case for a number of reasons, because there was a witness statement which was submitted by one of the witnesses of one of the employees of GSPC, and he, in a very kind of emotional statement, said that he had been deputed to go to the oil field to scout the appropriate area for conducting the exploration activities. But on his way there, he was kidnapped and kept without food and water for several weeks, as a result of which his health deteriorated. And it was only later, because of the intervention of the highest levels of the Indian government, that he was eventually released. So you have, very concrete examples of being unable to perform, and the evidence was introduced by the claimant on the by GSPC to establish to the tribunal that, look, we physically could not conduct any exploratory activities. So what is suspended is very clearly mentioned in the contract, and that's what you have to pay attention to. Not every obligation is always suspended. Similarly, you have the example in the Halliburton versus Vedanta case. You have a very clear example of what can be suspended or what performance is excused, and how you can seek that excuse as well. You have to be, in the instance in the Vedanta case, there was a very specific notice period or notice requirement which had to be satisfied. So generally, when you're talking about force majeure, what you're talking about is the immediate suspension of performance. And if the suspension continues for a long period of time, then you may be allowed to terminate the contract. So keep that in mind when you're faced with a force majeure provision. What exactly is it, if you're the party invoking the provision, what exactly is it that you want to do? Do you want the obligation, your obligations or certain obligations to be suspended? Are you looking for an eventual termination? Or is the objectives, are your objectives met using certain other flexibilities in the that may be available in the contract? Not every not every contract contains a force majeure provision, and therefore, in the absence of your contract containing a force majeure provision, you need to be aware of what other options you have, and that's what I was saying earlier. In some instances, it's possible that you want to immediately terminate the contract because it's impossible for you to carry it out at all. In certain other instances, it may be that you want the full contract to be completely renegotiated. In these instances, it's even if you have a force majeure clause provision, force majeure clause available, you may not want to rely on it. It simply doesn't meet with the objectives that you want to achieve. In that case, there are certain other provisions that you could rely on, and we're going to talk about those in a minute. You have, for instance, the doctrine of frustration, which we will turn to immediately. And then you have the doctrine of hardship, which I will come to later. But to close on force majeure, what I wanted to say is that you have to be careful about, firstly, whether your clause incorporates a force majeure provision or not. If it does, then the general understanding is that the tribunal or the court will apply the provisions of that clause and will apply it rather strictly, apply it rather narrowly. Each word will be given effect and applied stringently. If you don't have a force majeure clause, or if what you're eventually going to obtain from invoking force majeure is not something that you actually want, then you may turn to other doctrines, one of them being frustration. Now, on frustration, I'll turn to Varad to set out just the essential elements of frustration, and then take the floor again to talk about hardship. Varad, over to you.
Thank you, sir. Now, the doctrine of frustration is dealt with under Section 56 of the Indian Contract Act. And Section 56, Clause 1 starts with the present I. That is, if you and I contract to do an impossible act in itself, then the contract is void. After talking about present I, it then goes in futuro and says that a contract which becomes either impossible or unlawful by supervening or subsequent events, then it becomes void. And the voidness attaches from the point of occurrence of such supervening or subsequent event. So this is the broad scope of the statute. If we can move to the next slide. Right. Satyabrata, these are a few landmark cases. There is obviously a plethora of jurisprudence, 70 years of Indian cases, 400 years of English case law jurisprudence. But these four rather, are the most significant or seminal judgments which we may have to note for understanding the concept in a reasonably complete manner. So the first case was the Satyabrata Ghosh judgment, where Justice B.N. Mukherjee adopted the reasonable man's test to uphold an original understanding of possibility in Section 56. What he held was that an impossibility does not mean merely literal or physical impossibility. What is important is to ascertain what the parties themselves contemplated at the time of entering the contract. He therefore introduced an element of subjectivity into the concept of frustration. Now, 6 years later, in 1960, the Indian Supreme Court, without citing Satyabrata Ghosh, reversed its course and held in Alopi Prasad that courts do not apply Section 56 because it is just and reasonable to excuse the promisor, but because in its true construction, it does not apply to a given situation. So in this case, Alopi Prasad called upon the judges to identify what the force majeure clause actually meant. In 1968, we had the Dhruv Dev's case, which once again relied on Satyavrata Ghosh and upheld the originalist understanding of frustration. And the same year as Dhruv Dev, the Indian Supreme Court in the Naihati Jute case relied on Satyavrata Ghosh to canvass the facts to implicate the intention of the parties as the determining factor. But it differed from Satyavrata Ghosh on one count, when it went on to conclude that if a party has taken upon itself an absolute obligation to do an act, then in that case, no excuse can be made for non-performance, either by creative implication or even by judicial absolution. Finally, so if we can move to the next slide, please. Finally, in 2017, Justice Nariman in the Energy Watchdog case relied on Justice Mukherjee's judgment in Satyavrata Ghosh and summarized the principles of frustration under Indian law. He laid down that the element of subjectivity that was introduced in Satyavrata Ghosh could only hold water when the dissolution of contract took place under the terms of the contract itself. That is, when you had a force majeure clause in the contract. But Section 56 would only apply in an objective manner when the contract becomes impossible of performance and crumbles down due to an outside force. So we can move to the next slide. So from this discussion, I have culled out a few principles that emerge for us to take note of. First, the intervening event must so radically change the subsequent situation that the very foundation which subsisted underneath the contract, as it were, gets shaken. Now, for instance, in the context of the COVID-19 situation, the lockdowns imposed by governments may be considered as fundamental changes in manufacturing or construction contracts. Similarly, for supply contracts, since all railways and flight operations are suspended, a clear fundamental change in the contract may be taken. Second, courts have no general power to absolve a party from the performance of the contract, merely because obligations have become burdensome on account of an unforeseen turn of events. So commercial unprofitability, increased costs, unavailability of materials or disruptions in supply chain will rarely lead to a frustration of the contract. Third, the supervening circumstances, if they were within the contemplation of the parties at the time of the contract, or which could be within their contemplation, fall out of the purview of Section 56 of the Act. So an abnormal rise or fall in prices or a sudden depreciation of currency do not by themselves affect the bargain made by the parties, as these are risks which, especially you think of the oil and gas sector, are assumed by the parties to commercial contracts, or to oil and gas contracts rather. The fourth principle is that a contract cannot be frustrated where there are alternative means of performance available to a party. And finally, the essence of frustration is that it should not be, as we saw in the essentials of frustration, it should not be due to the act or election of the party. And it should be without any default of either party. So the test of frustration for us is today objective, as the law lays down. And this merely disappointed objections by the parties do not lead to frustration. Now, a more relevant question is, or rather, this question has turned into a FAQ recently. So if we may move to the next slide, please. The question is whether COVID-19 is a force majeure event. And the Delhi High Court, in its Halliburton versus Vedanta judgment, offered us some insights into what may constitute or whether COVID-19 would justify non-performance. And the court therefore laid down a few facts which have to be ascertained. For example, as you may read, the court would have to assess the conduct of the parties prior to the outbreak, the deadlines that were imposed in the contract, or the steps that were to be taken, and the various compliances that were required to be made. And therefore, the ratio that was laid down here was that Vedanta extended deadlines even before the lockdown was imposed, and therefore it could not invoke force majeure for something which had done before the lockdowns were imposed. And therefore, COVID-19 cannot be claimed as a defense by terming it as a force majeure event when when you were supposed to perform the contract when lockdowns or governmental restrictions were not in place. With that, I now hand over to Rahul sir to take us through hardship and then also give us a few recommendations as to what the parties should follow in these unprecedented times.
Thank you, Varad, for that very clear exposition. And for those of you that are law students that are watching this and that have to give an exam on Indian contract law and the doctrine of frustration as it appears in the Indian contract law, I encourage you strongly to approach Varad after this event is concluded. He has a thorough understanding of the issues involved. On a more serious note, I think we've covered two fairly dense topics. We've covered them fairly quickly. So I did want to just take a minute to pause and emphasize the fact that they are extremely dense issues and that they do need to be considered in some detail before they are either invoked or even if you're just defending an invocation or responding to an invocation of force majeure or of frustration. In essence, of course, you have to turn to the specificities of the contract in question. And that's of critical and paramount importance. But in essence, just as a thumb rule, you should think of, on an increasing scale of difficulty, force majeure is a difficult standard or difficult to establish, but frustration is even more so, arguably. And when you're faced with an event that you consider to be a force majeure event, you may think of whether there are other tools available that kind of are the events in question may not be of a standard sufficient enough for you to invoke force majeure. And then rather than doing so, you may think of using other tools, and hardship is another tool, and I'll come to that in a minute. But keep in mind that the court or the tribunal will undertake a fairly sophisticated analysis of the contract. And bear in mind also, as Varad mentioned earlier, oil and gas contracts are very sophisticated instruments. Everything is well thought, well understood, and then written down and agreed on. So the court will inquire into whether your specific minute obligation that you claim you cannot perform you were actually unable to perform it. And for instance, in Halliburton, the single judge went into some detail into the contract and said, you were in default effectively even before the measures that you consider to be force majeure led to an event of force majeure were in force. So you can't then rely on force majeure to kind of excuse your earlier non-performance. In GSPC versus Yemen as well, the defense was taken by the government of Yemen to say that, look, the GSPC is relying on force majeure just to excuse its earlier bad faith and non-performance. The reality is that they had never in mind to perform, and they were lucky that this insurrection, riot, violent act, etc. happened, and that they are now claiming to kind of skirt their earlier non-performance under the umbrella of force majeure. And even in that case, the tribunal took out a fairly detailed analysis identifying which obligation particularly could not be performed and whether the other elements of force majeure were met or not. So it is not something which is simply available for claiming because it exists. It produces serious effects, and those need to be considered. Now, I'm conscious of the time, but the next topic that we have to talk about is hardship. And it's a topic that I take very close to heart because I've written my second master's thesis on the doctrine of hardship, and particularly on hardship in oil and gas contracts. So I've written several, probably too much on this issue already. And to condense it to 5 or 10 minutes is almost is extremely difficult. But what I did want to set out at the time that we have available is just to help you to identify the differences between force majeure and hardship. Hardship is a usually contractual provision that appears in oil and gas contracts, which allows a party to seek a renegotiation of the contract or a rebalancing of the contract on the basis that because of certain changes in circumstances, the party can no longer perform the contract as originally envisaged. So it is different from force majeure in the sense that it relies on a different set of circumstances in order to seek not a suspension of the contract or a termination of the contract, but a rebalancing of the obligations of the contract because of the occurrence of certain external events. And it's best explained as usual with the help of an example. Now, this is a fairly old but fairly popular case as far as the doctrine of hardship is concerned, and this is the hardship provision that was applied by the English courts, or that was interpreted by the English courts. And you will see what they mean by hardship here. What has to happen is there has to be a substantial change in the economic circumstances of the agreement, which has caused one party invoking the clause, to have suffered substantial economic hardship. The parties will then meet together and try to renegotiate the contract and arrive at a mutually agreed rewording, rebalancing of the contract. If they are unable to do so, they then turn to a third party, which could be either a court or a tribunal. Now, you have hardship provisions in contracts, and you also have hardship provisions in some domestic laws. And for instance, I've put here the hardship provision in the French Civil Code. And you'll see here that the conditions are slightly different from what was present in superior overseas. So here the performance must be excessively onerous. Note the difference again with the doctrine of frustration. Not impossible. It's here sufficient for you to prove that it's excessively onerous, and that it shall, and the other important difference, until the parties agree to a renegotiation, the party invoking the contract is expected to continue to perform its obligations. So there's no suspension like you have in the case of force majeure. There is a continuation of obligation, continuation of performance. And you then have the parties having to potentially try to agree on the termination of the contract or to renegotiate the contract or to ask the judge to amend the contract or to terminate it. Now, hardship is a very unique contractual and or legal remedy, which effectively, if taken to an external third party like a court or the tribunal, puts the court or the third party in a unique position, very unique position of effectively having to fill in the shoes of the party and come to a conclusion as to how the contract should be rebalanced. Now, for those of you that are involved in the oil and gas industry, you know that these contracts are very sophisticated. A gas pricing provision, for instance, is just the pricing part of that consists of multiple elements, multiple variables, relying potentially on multiple indices, multiple hubs, and therefore to ask the court to fill the shoes of one of the parties and come to a conclusion as to which indice should be relied on, as to which indice should be, or which particular commercial term of the contract should be altered, is quite a serious ask. And therefore, these provisions are also to be taken, to be considered seriously. You may very well come out with an outcome that you're not happy with. The court will try to rebalance, but may do exactly the opposite. And if you consider and you read the superior overseas contract judgment that I cited on the earlier slide, you can read through the decision and it sounds very convincing. But the fact of the matter remains that both parties to that, both the claimant that was seeking the rebalancing and the respondent that said that no rebalancing was required, both parties fundamentally disagreed with the rebalancing that the court eventually ended up doing. So be careful when you're in a hardship context, because you could very well end up with a result that you're not happy with. So I hope that gives you, I'm not going to spend time on the contours of hardship. I've spoken about them and we're running out of time as well. I do want to leave some time for questions. Do keep in mind that there are fundamental differences between the three doctrines that we've just mentioned. And I just wanted to emphasize that here before we conclude. When you're thinking about force majeure, and I suppose here you could add and or frustration, the performance in the first instance in force majeure must be impossible. Now, again, the definition of impossible and to what is more a question of degree, and that is to be interpreted by the tribunal or the court in the context in which the force majeure provision appears. But it must be, as a thumb rule, more or less impossible. In hardship, that's not necessarily the case. It could simply be more burdensome. In terms of consequences, force majeure will generally lead to an immediate suspension of certain obligations under the contract and could eventually lead to a termination. In hardship, that's not necessarily the case. The expectation is of continuation of performance, and at the end of the process, you expect, or the party invoking it expects to have a rebalancing of the contractual equilibrium. The reason you would claim or invoke force majeure is what I've just said. You would either, it's because you want to suspend your obligations. In the hardship context, it's more because you want to renegotiate. And when we're talking about coronavirus, COVID-19, and the oil price volatility, I think you're more likely to see hardship provisions being invoked to the extent that they are available, rather than force majeure provisions being invoked, because parties are interested in continuing their contractual relationship, but they are simply unable to do so because of the complete kind of meltdown that has happened, unanticipated meltdown that has happened because of the combination of COVID-19 and the oil price volatility. Now, in terms of circumstances, force majeure events, as we've mentioned, are generally events where we would exclude commercial events. So if something is somehow more expensive or more onerous, it would not be sufficient. The fact that the raw materials that you had to source have become more expensive is not sufficient. The fact that you have to, instead of shipping your gas directly through the Suez Canal, instead of routing it through the Cape of Good Hope, is not sufficient. What you need is to have something that your performance was actually rendered impossible, not more expensive. Contrary to hardship, again, in hardship, you can say that the commercial terms of the contract are simply far more expensive beyond the contemplation or the reasonable contemplation of the parties when they enter into the contract. So there are fundamental differences between these two doctrines, and very often you have a combination of provisions that appears in sophisticated oil and gas contracts. In some instances, you may have one but not the other, but then you can source the other from the applicable law. There are several variations, each of which have to be considered quite seriously. So with that, I mean, I'm not going to run through, I'm going to not going to talk about these slides in detail, but I do want to flag that the Indian government has been fairly, I think, proactive in reacting to the coronavirus crisis. There are certain declarations of COVID-19 as being a natural calamity, of being a disaster, of declaring it as an event of force majeure in respect of certain contracts. So you need to be aware of these developments because you can rely on them in a particular case. In terms of recommendations, keep in mind, and I think this is a point that Varad made well, you need to keep in mind that you have a duty to mitigate, to undertake best efforts. If there is something that you should be doing in order to prevent the effect of coronavirus oil price volatility, then there's an expectation that you will undertake that despite eventually claiming force majeure. Follow the notification requirements that there are in the contract that applies to any obligations under the contract really. There are certain chambers of commerce that are issuing certificates of force majeure. You can choose to rely on those. In China, for instance, there have been a large number of force majeure certificates which have been issued. All of this will kind of buttress the arguments that you're making as the party invoking force majeure, that you were actually prevented from performing your specific obligations under the contract. And if you're responding to a force majeure notice, the simple advice is that you have to pay attention to the details. The devil really lies in the details. You have to insist on all of the specific particular requirements of the force majeure provision being fully satisfied. Similarly, in the case of the hardship provision, every requirement has to be satisfied, and insist that the standards or the thresholds that are set are high, and that the party invoking them has not necessarily invoked them correctly. Of course, all of this has to be done in the background in the context of good faith, and you should keep in mind that there are certain risks that you have to keep in mind the risk allocations that in any event appear in the contract. So with that, just 3 concluding remarks, and Varad will add more if he has them. Expect more force majeure notices, expect more reliance on frustration, expect more reliance on hardship provisions wherever they are present and available. Pay close attention to contractual and legal specificities. We've already seen an invocation in the oil and gas industry in a fairly sophisticated oil and gas contract, and there's likely to be many cases more. And bear that in mind before invoking or before embarking really on a path claiming either force majeure, frustration, or hardship. So with that, we end our presentation, and we're happy to take any questions that you may have. Unless, Varad, you have, of course, something that you would like to add, in which case feel free to do so.
No, so I think we'll go to the Q&A session.
Excellent.
Everyone, please send in your questions on the chat, and I'll read them out just now. The first question is, with the implementation of force majeure and hardship clauses in oil contracts surging, what is the probability of greater focus on alternate energy and the modification of force majeure clauses therein?
That's a very good question. I hope that there is a greater focus on alternative energy. Unfortunately, I think the commercial realities will make that almost impossible. I think that as it is, that the overheads currently as we have them for engaging wholeheartedly into alternative energy are high and are likely to be even higher because of the disruptions caused to global supply chains because of the coronavirus crisis. So I hope that it happens, but practically I think that it's going to be more difficult. In terms of modification of force majeure clauses, I think you've seen it. It's happened very instinctively, very reactively, and Varad will correct me if I'm wrong, but I understand that the ICC, that's the International Chamber of Commerce, revised its rules concerning the force majeure provisions very quickly after the coronavirus or COVID-19 was declared as a pandemic. They've revised their draft or model force majeure provision to allow parties potentially in the future to rely on global pandemics as events of force majeure. So there has been a reaction or a modification of force majeure clauses in reaction to the current crisis being faced by the oil and gas industry. So Varad, if you have anything to add, feel free.
No, sir. So I think the ICC force majeure clause is a good read for everybody because it really provides a bellwether as to where parties should be looking at, especially after the pandemic. And that's all I have to add to.
Sure.
All right. Next question is, could you please elaborate the difference between frustration and hardship?
It's no different from the differences that I've put out. There are many differences, but I think on the penultimate or the last few slides, we put out the differences between force majeure and hardship. And I think the frustration, you can say force majeure and or hardship. Force majeure and or frustration and hardship. it really is meant to do two different things. Frustration would commonly put an end to the contract, absolutely. And in hardship, the idea is not to end the contract. The idea is to rebalance the contract, but continue very much the contractual relationship between the parties. So you can turn back to the slides that we have. Varad, if you have something to add, again, feel free.
No, sir.
I mean, frustration is a very high standard to meet.
The next question is from our YouTube chat. How will COVID-19 impact trade relations between oil exporting countries and India?
Oof, look, the fact of the matter is that I suppose the good and the bad news about the pandemic is that it's affected everyone globally. The extent of the effect is, of course, different, right? The tourism, transportation sector is feeling the impacts of coronavirus more than, for instance, in the immediate present, the legal sector will, because there are certain transactions and disputes, etc., still ongoing. How it will affect India in particular is an interesting question. With governments all over the world, kind of signaling to their respective departments that they can, or their respective ministries, that they can issue force majeure notices, force majeure certificates, or classify COVID-19 as a national calamity, etc. There are reasons for doing that, and that's because the government potentially would like to obtain some flexibility when it's purchased in its purchases. And India purchases a large amount of hydrocarbons, as we've seen. It is likely to have an effect. And the advantage, or the thing that I can say, is that this is a fairly sophisticated sector, even amongst the oil and gas industry, particularly in India, is a fairly sophisticated sector. If you read the arguments that were made, for instance, in GSPC versus Yemen, you'll see that they are of a very high level, industry standard kind of arguments. Parties are aware of their rights. The contract is very sophisticated. So you can imagine that the Indian government will, and its in agencies, instrumentalities, will use all of the flexibilities that are present in its current contracts to obtain the most that it can in the result of the crisis. And it affects the government both ways, because we also have exports. So we have to play a balancing role there. But I expect, yes, there will be quite heavy renegotiations as a result of the pandemic. Not everyone wants a termination. They're happy with the contract, but they just need to redo it, which is why hardship, potentially.
Do we have time for one more question?
Yes, sure. Sure. They're very interesting questions. I'm happy to answer them. I must say that I'm very impressed in general with this latest batch of law students. Definitely, there's more diligence and enthusiasm on a Friday evening than I have ever shown when I was a law student. So it's impressive.
The next question is, sir, in your opinion, due to this pandemic, do you see a sense of laxity and complacency creeping into performance, warranting any additional provisions in the contract?
Warranting any additional provisions? No, I don't think so. I think you will have to, laxity and complacency will be checked by the court or the tribunal in question, as it has been in Vedanta versus Halliburton. I think that's a very good example of how the courts will say, you were already you were already not performing before. So now don't try to rely on the coronavirus crisis to kind of skirt away or shy away from your existing obligations. And I think the contracts are fairly robust. I don't think we need to kind of think of other provisions that could potentially be introduced. I mean, you can't contemplate and therefore enter into writing every possible event. You'll have contracts as long as theses. Transactional lawyers would be happy. Dispute resolution lawyers like myself would weep.
So I think our time is about to run out. If you'd like, I can ask you another question. We do have a couple, or we could end the session.
Let's take the two that have come in, and then I'm afraid I must leave.
All right.
But again, I mean, if anyone has further questions, I'm happy to answer them. Feel free to write to Varad and me. You will get our email from Spill, and we have a general interest in this area, so we're happy to take your ideas on board and discuss them in greater detail for sure.
All right. So the next question is, suppose it is construction contract and due to unforeseen conditions, cost of materials doubled, aggravated party invoke hardship provisions. If cost of materials becomes half its original cost, is there any opposite of hardship?
I'm not sure I fully follow. So the cost of raw materials increased considerably, and therefore a party seeks to invoke hardship. If that's the fact pattern, I don't think it is sufficient to invoke hardship, because you would have to prove that the cost of the raw materials doubling was something that was outside of the reasonable contemplation of the parties at the time that they entered into the contract, and that seems difficult to do if it's only that event. If there's been a combination of external factors that have otherwise affected a broader swath of performance, then you could potentially invoke hardship. And if there was a second part to that question as to whether there's counter hardship, I don't know what you mean. Counter hardship is the application of the contract itself. The contract survives, the contract must be applied and enforced as such. But maybe I've missed something, and then Varad will correct me.
No, sir, I think that's pretty much it. So, I mean, we've seen in the construction sectors, the RERA authorities in 23 states of India have allowed for an extension of the timelines which were given. But apart from that, especially in terms of the raw material, again, as you said, it will all come down to what the contract says and whether it was in the contemplation of the party.
The last question, although price volatility is generally accounted for in oil and gas contracts, could price volatility in other sectors owing to COVID lead to invocation of force majeure, or would that not be condoned as it is a commercial risk?
That's a fascinating question. I'm glad whoever it is asked that question, because that was effectively the subject matter of my master's thesis. The price volatility most definitely is not sufficient. What we're talking about here, though, is a price volatility of a kind that has not been seen for over a decade, or ever since there was a sophisticated recording of prices in the oil and gas industry. There's not been this level of volatility. So normal volatility is a part of the commercial risk, but when we're talking about the volatility that we are seeing now, I believe that it is exceptional enough to warrant a claim for hardship, subject to other circumstances being met, of course.
All right, would you like to conclude the session now? Because I think you do need to attend another conference.
Yes, please. I have to, as much as I would like to continue this fascinating discussion, I'm afraid I have a lot to do still before I can enjoy or think of enjoying my weekend.
All right, thank you, Mr. Donde and Mr. Kolhe, for this very enlightening session with Mumbai and Anal. Also, thank you to all the participants for registering and joining and watching this webinar. A special thank you to working member of Anal, Abhay Pachauri, for being so cooperative with us. And yes, thank you so much.
Thank you very much for having me, and my congratulations for organizing these events. I think it's a good idea.
Thank you.
Goodbye to all of you. Thank you for your patience.